All right, everybody, welcome to the Creative Finance Collective. I'm Andy Fowler. Going to bring on a few of the folks that are joining us. Drew, can you hear me?
I can indeed.
All right, Drew Jenkins, our guy out of Georgia and Alabama. I know Sean's going to be joining us in just a second. If you're just not joining us, this is the Creative Finance Collective. We're going to be talking all things real estate and creative finance. If you have questions, our main purpose here is to be here to answer questions about creative finance and real estate type issues. So if you have a question, drop it in the chat. We'll be taking questions throughout the hour or until we stop getting questions. So if you want to engage with us, this is the time to do it and the time to post those questions. Also, there is a barcode at the top of the screen that takes you to our YouTube channel, which is kind of the best and easiest place for you to engage with us and ask questions and participate in the podcast and participate in the collective. So if you're watching on Facebook or watching on one of the other platforms, go ahead and scan that barcode, and that'll take you to the YouTube channel. I see here we've got Sean who's joined us. Sean, can you hear us okay? No, he's working on his audio. Drew, you can hear me, right?
I can, yes.
Okay, let me make sure. Let's double check the sound. How things been going with you over there, Drew?
Normally this is the slow time of year, but we're not actually terribly slow, which is a good problem to have.
Yeah. What is there anything particular that you're seeing a lot of? When you say slow, it's just the garden variety of stuff that's keeping you busy, closing deals.
Right. Yeah. Normally things really slack off around the holidays and they don't generally start to pick up again until we get closer to sort of end of school. Sort of what I tell my people is so long as we pick up by the end of March, we're fine. But we barely slowed down this year. So that's a good problem to have.
Okay. So the so you didn't see anything really beyond just the normal holiday slowdown. You haven't seen any like appreciable slowdown due to, rising interest rates or anything else in the market?
No, we slacked off. I mean, once rates went up, a couple of I guess summers ago or the other summer ago, things slowed pretty dramatically. Our bridge lenders that we work with have pretty much rebounded entirely. I mean, we get, it feels like two files a day from them. So that end of the market is picked back up. Everything slowed, but it's not dead. Right. And normally, things would be dead around Christmas, January, February, but we're definitely nowhere near that. Like we still have, I mean, we have a pretty heavy load for this time of year.
Yeah. Sean, are you able to hear us now?
Yeah, I am.
All right, we can hear you fine. Sean, I know you help a lot with closing of creative finance transactions. Have you seen any slowdown, or is it still business as usual?
Still business as usual, but I think that's to be expected with this market. I think with the high interest rates and stuff, I think subject to is still the way to go, and so I've not seen a lot of slowdowns.
I
All
will tell you
right.
all this, an interesting one. I just had a friend get an apartment complex under contract today. And there is a Fannie Mae small business loan that's on it. And of course, the thinking was, given the amounts and the fact that it's multifamily, is that my buddy was going to take a second with traditional financing to help with the down payment, right? Because it's still pretty dear, but to lock in that assumable rate. But unbeknownst to any of us, including the brokers involved, no one had ever handled an assumable Fannie Mae small business loan. And apparently we learned at the sort of mid part of last week that they don't allow seconds, which struck us as kind of odd because, first position lenders shouldn't really care if there's a second involved. It's no skin off their back. So that forced us back to the drawing board. And so now, he's going to take out a line of credit against his other properties to generate the cash needed to take over the assumption. I mean, it's a pretty sweet deal that Fannie Mae gave him, but it struck us as odd that they wouldn't allow a second on an assumption. I don't know if y'all have ever dealt with that before.
I haven't. Have you dealt with that before, Sean?
Yeah, there's a lot of lenders, if they're outside of the purview of Garn St. Germain, which in this case it would be because it wasn't a residential home property. I mean, it's a multifamily. They do and can restrict seconds, and the reason why you would want to restrict a second from a business standpoint is because if they get sideways with the second and the second forecloses, well, you didn't agree to loan money to the second. You don't know how the second's going to treat or care for the property. You know how the purchaser at the foreclosure sale in the second's going to treat or care for the property. So it does put the asset at risk to have a second against it. Garn St. Germain states that for federally insured loans against single family homes, that you can't restrict seconds. And even if you put it in your loan documents that you can't have seconds, it doesn't matter because federal law says you can. But on the transaction you're talking about, Garn St. Germain wouldn't fall in. And yeah, there are a lot of lenders on those types of transactions, first position lenders who don't want seconds, even government lenders.
Right, and that's the part that we're trying to figure out is because a lot of us we've dealt with SBA, right, 7A and 504s, but none of us have ever dealt with a Fannie Mae small business loan before. And I said even the brokers were caught a little bit flat-footed by that because that was the assumption going in. Again, given that it's a sweet deal to assume, right? Very low interest rate, very long AM schedule, as befits a government-backed loan like this. And so obviously the down payment would be pretty high considering the low LTV that's left on it. So it was either someone's got to come up with, 7 figures of cash, or we got to figure out some other strategy to make this down payment happen.
Interesting. If you're just now joining us, we're just slow walking this to allow different folks to come on and ask questions. This is the Creative Finance Collective, and we're talking about all things real estate and creative finance related. So if you have a question, make sure to post it in the chat. Also, if you're watching us from Facebook or another platform, make sure to check out the barcode at the top of the screen there. That'll take you right to kind of our main YouTube channel, which is the best place to participate with us in the collective or on the NREM podcast. So go there and subscribe. We'd appreciate it. We have a question. Let me read this and pose it to you guys. And it's a pretty general one. What's the best way to get into creative finance? So somebody looking from at the ground level, how best to get into that. Now, that might be a tough question for lawyers because we're the ones that are there to make sure you don't step in it and do it the wrong way. There's probably better ways to start getting into it than just talking with the lawyers. Although lawyers probably need to be some of the first meetings that you're going to have. I don't know if Sean, if you disagree with this, but in interviewing on the NREM podcast, a lot of folks who have been on this, one of the best ways to really get in this and start learning is just to start attending networking events with real estate professionals in the space, to hear how they're doing it, to see what they're doing. There's a lot to generating leads and how they find the property, a lot of stuff way beyond what we as lawyers deal with. But what would you add to that, Sean?
So I agree 100%. Start networking with other investors. So the 2 pieces of advice that I would give is, number 1, start networking, and, subject to seller carry transactions can be wholesaled. And so maybe you have another investor or somebody who has found the transaction and, you like it and you're willing to pay an assignment fee to, be the end buyer on that. You can do that. Or the second way is that, you find the transaction, and then I would probably partner up with somebody experienced in the creative finance space and, connect with them and have them kind of assist you, maybe offer them part of the transaction to kind of walk you through the process, show you exactly, when to do what forms to do, how to make sure to set up the contract, the terms, everything, how to walk it through escrow, how to make sure that escrow does their job, all of that. So that's what I would do if I were trying to, get my feet wet.
How long along the timeline, or how soon along that timeline do you think they need to start? Somebody at the beginning needs to start thinking about meeting with a lawyer and start talking with a lawyer, and in terms of what the documents are going to look like, the transaction. I think it's probably pretty early. At a minimum, it's probably at the beginning in the form of a consultation to learn about the legal landscape of what you're dealing with.
Right. And, I come from, because most of my transactions that I'm involved in are here in Arizona. So I come with the Arizona mindset, which doesn't have tons of restrictions. But, you start venturing outside of Arizona and you better be consulting with an attorney. I mean, there's hefty consequences outside of Arizona, states like Colorado that have, foreclosure rescue laws and foreclosure purchaser restrictions and things like that, where you have to do tons of disclosures. And if you don't, you can end up with some pretty hefty civil penalties. So definitely consult with an attorney. Frankly, you don't even need to partner with somebody familiar with subject to or creative finance. We've had plenty of clients who have identified transactions that they like, and they come to us, and I say, okay, here's the fee, probably less than what you would pay somebody to partner with you. As far as giving them a piece of the transaction, here's the fee, and we draft up the documents. The seller and buyer execute them, and then we hand them off to the title company that we know will do a bang up job and close the transaction right. And we hand them off. Title company takes it from there and closes it. So basically, honestly, now that I think about it, and after hearing what you just said, Andy, I think the starting point is meet with an attorney. Have an attorney who's familiar with creative finance, familiar with subject to, lined up, ready to go. Find your transaction. Have that attorney put those documents together, circulate it. I mean, we'll circulate it. We'll get the parties to sign by DocuSign, and we'll submit it, hand it over to the title company, and they go from there. So I would say probably your first starting point is to meet with that attorney and make sure that you're dotting your I's, crossing your T's in the state you're doing the transaction in, and then also making that relationship so that you can have the forms pretty much ready to go when you find that transaction.
Yeah, and I think so often the case is that folks hear all the great things about something on YouTube or whatever else it is, and they decide that this is the space they're going to jump into without maybe analyzing the entire risk profile associated with whatever this investment strategy is. And there's, like it or not, risks associated with creative finance. So, it would stand to reason that you understand that and don't just stop with what a bunch of, guys say on a YouTube channel. Find a lawyer in your state. They don't even have to be a creative finance lawyer that does these transactions, like Sean said, all the time. They just need to be a real estate attorney that understands liens, mortgages, due on sale clauses, and so on and so forth. And every lawyer is going to be able to give you an appreciation for what the risks are associated with that, what they see in their state, what you need to be prepared for. I mean, Drew, I don't imagine you see that a whole lot differently, that somebody probably wants to hit up with an attorney pretty early in that assessment.
So obviously, we don't know who all the YouTubers and the different groups are out there that pitch, become a wholesaler, become a real estate investor. But at least around here, and again, I always know when a seminar came through because people will call me trying to set up an appointment to know if I do double escrows or if I do seller financing, right? And all just kind of basic questions. So at least some of those groups, they recognize that you need to get the lawyer involved pretty quickly, again, to make sure that, hey, can you review my documents, something like that. So I agree 100% is make sure that what you're doing is legal in your jurisdiction, right? as Sean was saying, there's a lot of changes there. But the other thing that you need to be really careful of when you get involved, and I used to tell clients back this when I was back in Alabama, is if you are just now getting involved, not just in creative financing, but in the sort of broader wholesaling space, I tell people, recognize you are the mark. Right? There are going to be unsavory people that are going to pawn off properties on you for far higher than they're worth. And so that goes back to your point of making sure that you're networking and that you at least are acknowledging your ignorance in this field, and that you need to do a little extra due diligence to make sure that you're not overpaying for properties. Because, I mean, by its very design, this market is very much off market, right? And so you need to be careful and that you're not overpaying for a property.
Yeah. All right. If you're just now joining us, this is the Creative Finance Collective. We're taking questions throughout the hour until we stop getting them about creative finance. So make sure to post them in the chat. If you're watching us from Facebook or another venue that is not YouTube, go and scan the barcode in the top of the screen. That'll take you to our YouTube channel where you can subscribe and better follow our content. We have another question here, guys, from a YouTube watcher. Does the due on sale clause cloud title? What do you think, Sean? How would you answer that? Does the due on sale clause cloud title?
So, and there's a secondary question that I see on that. So I'll kind of answer both due on sale clause here. So the answer is no, it doesn't cloud title. It is in the lien document created or evidenced by either a deed of trust or a mortgage. So the deed of trust or mortgage create a lien, and within those documents is a clause that basically says, hey, if you go sell the property, we as the lender have a right to accelerate the indebtedness and require that it be paid in full. So that brings us to the next question is, can the due on sale clause prevent you from selling the house and make you give it back to the owner? No, the due on sale clause can't prevent you as the owner from selling the house. So if, I'm assuming that this question, based upon its verbiage, is of a scenario where you've acquired property subject to an existing loan. That existing loan has a due on sale clause. The lender finds out about it. The lender's like, hey, you sold the property, seller, now you need to pay me. What can the buyer do? And the buyer can go and the buyer can sell the property to a third party and pay off the loan. In Arizona and even by federal law, a owner of property has a right to receive a payoff statement from the holder against that property, even if they weren't the borrower. And so they have a right to go and say, hey, what's the payoff of the loan? Give me that. I'm going to sell it to this third party. They're bringing cash to the table, or they're getting their own financing, and we're going to use those funds to pay off your loan, and you pay it in full. And the lender can't stop you from doing that, even if the due on sale clause has been violated. So you aren't required to convey title or put title back into the seller's name. All you're required to do is pay off the loan, either through a sale, refinance, or bringing your own cash to the table. Drew, does Georgia have a statute that requires that payoffs be delivered in a certain amount of time? Arizona, it's 14 days, and there's a number of people, including a successor in interest in the property, who can request that payoff. What's the law in Georgia on that?
I don't believe that we have such a statute.
Or Alabama.
I know Alabama does not have one. I know that when it comes to failing to release your lien within a certain period of time, if the lender fails to do that within 60 days after receiving notice, then, they owe you $500 as, the original borrower. But I don't believe our states have gone so far as to legislate the request for payoffs. Because again, that's something that we've run into in Alabama is, the bank just refusing to provide a payoff because conversely, they point to federal law and say, you're not a borrower, and that's NPI, right, in order to get it. And they deny, being able to provide the payoff absent suing them in court. So every state does it a little different.
All right.
I did want to point out
yeah.
one interesting. Yeah.
Yeah.
Go ahead.
Go ahead, Sean.
I think there are and maybe it involves the release of the deed of trust, but I thought there was some federal law requiring that for not maybe it's a like a administrative rule or something that you have to provide a payoff under federal law for FHA, Fannie Mae, Freddie Mac loans, and to anybody with an interest in the property, even if it's a secondary lien interest or successor in interest.
And
But
that may be
I
true,
could
but
be
that doesn't
wrong.
mean that the payoff people in Alabama know that. I mean, I'm an attorney and I'm not even familiar with it, right? So I mean, I can't expect them to necessarily be familiar with it either.
Fair enough. All right. If you're just now joining us, this is the Creative Finance Collective. If you have creative finance questions, post them in the chat. We're going to get to as many of them as we can. Have another question here from another YouTube subscriber, kind of another beginning of the beginning stages of thinking about creative finance. If I'm starting from the beginning, what is the most important thing to understand in creative finance? Well, I think, my thought is the most important thing to understand is that you're buying it subject to a loan that has not given you the authorization to transfer the property, and you're going to be buying it to certain terms that have risk associated with it, which is going to require some disclosures. And there's some risk that's not a part of that is unique to the creative finance transaction. That's not a part of a conventional transaction. So I think that going into it, being aware of those risks. What would you say? Anything different, Drew or Sean?
I would agree 100%. And just like we've said, we know when seminars come around because that's when people start calling with, very basic questions. And, the seminars make money by telling you how easy it is and how rich you're going to get in this space. And they either gloss over or just do not actually detail what the risks are. And again, so long as you understand the risks and you're okay with the risks, and so long as your counterparty understands the risks and are okay with the risks, then you're probably fine. But it's been my experience that it either the person entering creative finance either doesn't understand the risk, or they may understand it, but the counterparty has not had it properly explained to them, and so things can fall apart when that happens. I'll give you a great example of that. Is, and I think I told you that before, is I had somebody, again, came off a seminar looking for a lawyer. He and his wife set up a meeting with me, and he thought that title insurance would protect him from the first mortgage that he was going to assume. He's like, that's what title insurance is for. You'll pay it if they call due on sale. And it's like, no, it does not protect against that. You bear that risk, not us. So it's a lack of actually understanding the risks.
Yeah. All right. Another question we have here. What are some strategies have you seen investors use to postpone foreclosure auctions? Well, I guess what I would say in Arizona, most of our foreclosures are non-judicial foreclosures in the form of a trustee sale. Under Arizona law, you have to seek to stop the sale before 5 p.m. the day before the trustee sale, so they have to go into court and get an injunction to stop the sale. Some of the reasons for so that's really what you have to do. In order to stop the sale, usually you'd be finding reasons like that the trustee failed to follow certain notice requirements under the statute or whatever else, and a notice wasn't potentially given. That might be a way to do it. That's the way you're supposed to go about stopping a trustee sale. That doesn't mean that you have a good basis to do it, but assuming you do in Arizona, that's how you would go about doing it. I've seen different folks. I don't even want to tell the story to suggest the strategy, but I've been brought into different venues as a trustee, and the trustee sale got stopped because of probate issues before and different things. So usually they all they go around notice, I think, or the failure to give notice. That would be what I've seen. I don't know, Drew or Sean, you have any other thoughts on that?
So it happens fairly regular. A good portion of my files, especially these days with the way the market went, are probate related. And so yes, if you like want to like legally enforce a stop, to a foreclosure, you're going to have to go to court in some manner and get a judge to stay you. But here it seems to be a lot easier than that, both in Georgia and Alabama, in the fact that if so long as you actually have like a good faith purchaser for value and you have a legitimate contract and there's legitimately earnest money, my clients here have been extremely successful at just submitting that to the lender and say, hey, give us an extra 30 days. And the lenders generally, because they don't actually want the property, I mean, they can't do anything with REO either, right? And I have seen foreclosures get stayed, not because legally a judge forced them to, but because the lender agreed to give an extra 30 days, right? And to reset the clock. In fact, we've got one file that was under the gun all the way back in November. And to my knowledge, as of February, it has still not actually been foreclosed on. So I don't know how she's pulled that off, but she has managed to keep resetting that clock now for what? December, January, February, and now we're into March for almost 4 months. Now, that has other problems. She has 5 separate contracts signed, but that's neither here nor there. So you can certainly drag it out so long as you haven't really royally, ticked off your lender, right? They will give you legitimate time under a legitimate contract to sell, at least here in Georgia and Alabama, in my experience.
Yeah.
Yeah, Drew's right on that. Basically, lenders, they don't want to own real estate. They would much rather just be paid in full. And if it looks like, a likelihood that that's going to happen, then they're generally willing to postpone the trustee sale. But it is a negotiation. So in Arizona, like you said, Andy, it's almost impossible to stop a sale. You have to go in and get a TRO, or maybe you can do something through probate, that type of thing. Another strategy, which is illegal to do, but I know it's been done, and I would say I would not do it. I would advise instead is the filing of bankruptcy. I wouldn't even say it's a strategy, not legal. I mean, not legally allowed. It's bankruptcy fraud to file for the sole purpose of trustee sale with no intention of taking the bankruptcy to the conclusion through a discharge. I mean, if you go and file for bankruptcy without the intention to discharge your debts, that's bankruptcy fraud, and you're not supposed to do it. So to the extent that, investors are trying to do that, I recommend against it and say, no, don't do that, because you and the borrower are going to get in hot water. But a bankruptcy does, if a borrower legitimately is going to file for bankruptcy and they want to discharge their debts and they're going to take it through, the bankruptcy will stop a trustee sale. A bankruptcy filed 10 seconds before the gavel drops on a sale, even if the trustee doesn't know about it, creates an automatic stay, and the whole sale has to be rescinded and set aside.
Yeah. And as a trustee on trustee sales, what I've told them is, hey, look, your best strategy to stop the trustee sale is just reinstate. I said that on the stand once to when they were trying to stop a sale, and I kind of, from the questions, I could tell that the individuals and the lawyer trying to stop the sale didn't realize that they could reinstate. And I was like, one of the things you could do is just reinstate and pay what's owed. And there's nothing I can do to stop you from doing that. If you pay that before the sale, we have to stop it by law. And they're like, oh, okay, we'll go find the money and do that. And that's what they did. And they stopped it, and everybody came out whole, and my people got paid and they got paid. And, but sometimes they don't even realize they've got that right. A follow-up question, Drew, to what you were saying, the same YouTube listener, Drew, does that raise any flags when the deal is subject to? Trying to recall what you said that this is in response to, but it was in response to your last comment.
So if you are, and I've had clients try and do this before, where you are in a foreclosure and it's exactly what you said. I'm glad you brought it up. Is the first thing that they do is they reinstate, because obviously you never, and correct me if I'm wrong on this, you never want to buy a loan that's already in foreclosure, right? Like, I mean, I would think that the risk profile on that is so obscene as to make it a non-viable deal, right? Because you're not the borrower. So part of that would be, and in the one case, they actually did wind up reinstating the loan, right, first and foremost, and then once that was squared away, they did the transaction. But I mean, if I don't quite grasp entirely. So if you could rephrase a little bit to clarify it, but if it's with respect to trying to do a subject to that the first position is already in foreclosure, I mean, you have to somehow get the foreclosure process like kind of permanently off the table, I would think, before you agree to buy such a thing. Otherwise, you're going to lose that property real quick.
Yeah, I think that's right. All right, another question. How will I get notified if the loan I purchased sub 2 is sold? So I think where this is going is I'm a buyer on a sub 2 deal, and what happens to notes on the secondary on the open market? They get bought and sold. We've all received, new statements from new loan servicers or whatever else saying, "Hey, we're servicing this loan now, send payments here." So the question is how will I get notified of that? Sean, I think you have thoughts on that. Or
Yeah, so part of the subject to transaction and part of doing it right is to have a subject to addendum that lays out all the different documents that the seller is going to sign at closing. One of which is a limited power of attorney property. The second doc you're going to get is a change of address form where the mail for the loan is going to go to the address that you designate, so you're going to be able to get that servicing notification. And also, assuming that the loan's not connected with virtual accounts, it's not like bank and you're going to get into their online banking, online checking accounts and stuff, but it's just an online loan account through the loan servicer that you don't have any type of the borrower is using for banking or otherwise. You get access to that as part of the transaction, so you can then see what's going on with the loan. And if you have online access, you'll see that the servicing's been transferred. You'll get the mail showing that the servicing's been transferred, so you'll get notified just like the borrower would otherwise get notified of the servicing transfer.
that's a big thing that I think you said, and it's worth repeating. If you set it up correctly, right? This is a serious problem, and I think the issue is if you don't set this up correctly with powers of attorney, you're not going to get notified, right? You're in complete reliance on the seller if you can find the seller.
And that's exactly right, assuming the seller is even willing to, continue to deal with you after they've sold the house, right? And that goes back to the fact that people, they don't, if it is to your point, if it's not done right and you don't have the right paperwork, people don't understand what their obligations and their risks are in the transaction. And so, they think they've sold their house, they got paid, they're going to wash their hands of it and move on. And if they get paperwork, it's not their problem. And to an extent, it's not their problem. It's your problem, which, if it's not handled correctly, will become their problem, right? So either you have to have something that lets you legally be them, as he said, a LPOA, or you have to stay in contact with your seller, and y'all are going to have to kind of shepherd this thing along until the loan gets paid off in full. Your choice.
Yeah. Yeah, and usually in the transaction documents, we'll have some sort of cooperation clause which demands the cooperation of the parties, but you know how that goes. People don't even remember that they signed that, and that assumes you can find it. Much better off to be able to have the authority on the front end with like the powers of attorney to be able to do that. All right, if you're just now joining us, we're taking questions, creative finance related questions. This is the Creative Finance Collective. If you're watching from Facebook or another venue that is not YouTube, take your phone out, scan the barcode at the top of the screen that takes you to our YouTube channel. Click subscribe. That would help us. That's really the best place to follow this content and the INREM podcast. Have another question. Does a lawsuit cloud title? Does a lawsuit by itself cloud title to real estate?
I have a great answer to this because I just dealt with this on a file. Um, no lis pendens was filed of record, right? And so at least here in Georgia, and I can speak for Alabama, unless there's a lis pendens that puts us on legal notice that, hey, something's coming down the pipe, we generally can ignore it, right, for the purposes of closing. But in this particular case, we were made aware of it. There was no lis pendens filed, but we became aware of the lawsuit against the seller. And so we tracked the case, and the case resolved with a judgment against our seller. So we went back to our underwriters and we said, what do we do? They haven't filed a judgment yet, so it's not it's not a lien against the land, but there's what we call a gap period, right? Because we always have to recognize that the land records that you're buying insurance on are not up to date, at least in our jurisdictions. So there is a risk that before our deed is recorded, a judgment could be recorded. So what do we do? And the underwriters said, hold an escrow 125% of the judgment amount and, try and beat the clock, right? And, if we beat the judgment lien and our deed's recorded before the judgment lien is filed, then, we refund the money back to the seller. But if the judgment lien makes it to record before our deed, then obviously we get the payoff and we pay it off, and any excess goes back to our seller. So it won't actually stop the closing. It's not a cloud. But depending on, at least here, depending on the status of the case, it could potentially require some escrows by the title company. And obviously, if a brand new lawsuit is filed and no lis pendens is filed of record, then whatever, right? We'll just close and move on with our lives. But if there's a lis pendens filed of record, yes, we need to get involved. If there is no lis pendens filed of record of a recent judgment, we're going to need to probably do some escrows to protect title, because there could be a judgment filed. But if the lawsuit has no lis pendens and is nowhere close to judgment, then we don't actually care about it. That's pretty much it, at least from what we deal with here.
That's good information. Yeah, that's so you just ran into that one, Drew?
Just ran into that one in January. Yep. And so we knew about it, and we knew that it was coming, and we knew they
Yeah.
were close because they had already had all their hearings and trial or whatever. And then about a week before closing, we got notice that yes, in fact, a judgment was rendered. And to make things even better is we reached out to obviously the winner who hadn't filed the judgment yet and said, hey, we need a payoff because we would like to get this resolved, and she's willing to pay the judgment. And the lady's like, well, I know the judge only gave me 1,900, but she actually owes me X. And we're like, yeah, we're going to ignore her. We're just going to hold 125% of the judgment amount. And, if she gets her judgment filed before our deed, we'll pay what is owed. And if she doesn't, well, not our problem because she never secured her judgment against the property.
Yeah.
So it was
Sure.
just funny on that end.
Interesting. Interesting. We have another question. We'll go. It's a Facebook user. So we'll go to them. When buying subject, I assume that meant to be subject to, is there a way to better deal with a divorced couple? Can one be removed from the mortgage? One party is considering and the other is a pay on time. Let's see, is a pay on time freak. Any insight would be appreciated. So let's see. What do you think they're getting at? Trying to get one couple or one person off the deed. You run into this at all, Sean?
So, yeah, it really depends on the decree. So the decree is going to tell you exactly what has to happen. When the market was down and properties were underwater, most of the time they just awarded the house to one spouse or the other and didn't make them take them off because it was impossible to take them off because you couldn't refinance. Now with equity, they normally say that the spouse has to refinance and remove them from the mortgage within, a set amount of time. If the court doesn't do that and simply awards the house to one spouse over the other, and then requires that that spouse pay the mortgage, then you could do a subject to transaction with the spouse that was awarded the property. You make sure that, and Drew can speak on the title issues associated with decrees, but most divorce decrees are not done right, and don't effectively convey title to the spouse that, to whom it's been awarded, because it has some magic language and a legal description at the decree, and they do that. But assuming that the decree is done right, they award it, the mortgage stays in both spouses' names. The spouse who was awarded the property does have the right to convey the property, convey it subject to. But if the judge orders that the sum off, or the awarded spouse be removed from the mortgage within a set amount of time, then unfortunately they have to be removed from the mortgage, and they're going to have to either refinance or sell the. So that's kind of the situation there.
Yeah, I know we've always been of a mind that we'd like to see more divorce decrees, or more folks going through divorce get advice from a real estate attorney before that decree goes into place, because we've, just outside of even subto or anything else, just lots of real estate problems pop up. I would imagine, Drew, you run into that a lot with divorce decrees, just title problems.
Yeah, title problems, definitely. So one of the dangers is if one of the spouses are still very vindictive, sure, you can sell it subject to, but at least the way that our divorce decrees generally work here is just exactly what you were saying is, hey, you have X amount of time to either refinance or sale, and at sale or refinance, the non-receiving spouse is supposed to receive a certain amount of money. Right. So if you're attempting to do a subto and you're not going to be able to raise the amount of capital necessary to pay off the other spouse, obviously it's going to be a no-go anyway. But another problem that you run into, and you're going to think very, very hard about, is remember that one spouse, if they're vindictive and they're a pay on time kind of person, if they find out that they're still liable for a mortgage on a home that, even their ex-spouse has nothing to do with, nothing prevents them, and I know I've run into this more than y'all have, of calling the bank and just blowing it up just to blow it up.
Yeah.
Right. And there's really nothing that you could do to stop that from occurring. Here in Georgia, at least, so once a divorce is filed, basically no one can sell property, because spouses can create this equitable right. And we don't know whether or not the equitable right in the homestead exists, if or until, not even the homestead, anything really, if or until a judge tells us. So that kind of puts a pause on any real estate transactions involving divorcing couples when they're not both willing to sign on to the deed. And then, as he's saying, once you hit the divorce decree stage, we hope it's written clearly, but that's not always, I would even say that's not necessarily often the case, right? There's a lot of ambiguity in it. And I have had cases where I've had to send the divorcees back to court to say, we need you to get your documents clarified because you two don't agree on what it says. And obviously I only have a certain pot of money that I have to divvy up between the two of you, assuming this goes forward, and y'all can't agree on who's supposed to get what. So please go back to court and get us a better answer. So that would be my addition to this, is when dealing with divorced couples, if one's vindictive, you run a real risk of them just blowing it up just cause.
Yeah, good info. Another question: what is the biggest subto pitfall for buyers? What about sellers? So, in your estimation, the biggest pitfall for buyers, and what's the biggest pitfall for sellers? Or is it the due on sale clause for both?
No,
What do you guys?
I mean, I don't think the due on sale clause is the biggest pitfall. To me, the biggest pitfall for a buyer is trying to make a transaction happen that shouldn't happen. You know, sometimes it's just not going to work. And I see, unfortunately, buyers who want to basically do illegal things to make a transaction happen because they want to make the transaction happen. They hear how people are doing all this creative stuff, and it's like, oh, every transaction should work, and you should be able to do every transaction and close, and there's always a way to make it happen. And sometimes, you know what, there isn't. And don't force it, because that's when you get yourself into trouble. When you try to do something overly exotic that ends up not being, legal, or you're not giving, the full statutory state disclosures and different things. Sometimes just let it go. I mean, if the numbers don't work, you cannot, if the numbers don't work, don't basically partner with the seller to do a loan mod, to get a loan mod and make those numbers work. And that's fraud. You can't. So you may just have to walk away from the transaction. That to me is a major pitfall that I see with buyers, is trying to force something that sometimes it's just not meant to be. For sellers, I will say, what I think the biggest pitfall for sellers, and our investor folks on here listening aren't going to want to hear this. The pitfall for sellers is they don't negotiate a better deal. They have what everybody wants, and a loan against property with a low interest rate. You should be negotiating the heck out of that thing and getting a whole heck of a lot of money and making that a sweet deal. And basically you should have the negotiating edge over any other seller out there, and you should be getting more for your property, more for the transaction, if you allow somebody to take over your 3% loan. Because I'm using 3%. It could be 2.8, it could be 3.5, but your low interest rate loan, you know why? Because that's the golden ticket. That is the golden ticket, and there's only so many out there, and you may never see those golden tickets again. And once the property is sold and that loan is paid off, there's no more. So
start seeing your debt as
you're
an
going to
asset.
hand out. Yes, start seeing your debt as an asset. That to me is a pitfall of the seller. Is they don't see that, and they don't negotiate hard enough to, really take advantage of the fact that they have this asset out there that everybody wants.
Yeah, good take. So far that's all our questions so far. I did want to ask, we'll see if we get any other questions, but with a little bit of the time we had, Drew, I wanted to ask you, we were talking earlier today, and I don't mean to put you on the spot because this just came down. You may not have followed it at all, but I know you're licensed in Alabama, and an Alabama federal judge
Struck down the CTA.
Yeah,
Yes.
you knew right
Is that
where
what
I
you're
was
about to
going.
ask?
Yeah. Are you following that? What's going on?
So I'm following
Oh
it a little
man,
bit,
you
and
gotta love
apparently,
Alabama.
apparently, as soon as the ruling came down, one of my buddies texted me. It was like, "Did you see this?" But
Yeah.
apparently, I haven't read the opinion yet. But according to him, it's only applicable as to the plaintiffs for right now, right? Which is that National Small Business Administration, which strikes me as really odd that a law is unconstitutional for this person, but is perfectly permissible for everyone else. Um, I need to sit down and read the opinion. I just got around to reading the Supreme Court's Trump opinion, right, on that one. I have not yet had a chance to look and see what's going on with this one, but I mean, it's definitely interesting, and I guarantee you they forum shop this thing, because why else would they bring it in the Northern District of Alabama,
Alabama. Yeah,
right?
exactly.
Unless they thought that would be the most friendly audience they could find for such a suit.
Well, the law's only been in place since
Enforced.
January, or
Yeah.
enforceable since January. So that's a quick motion for summary judgment, man. They got that thing
Oh,
going.
but they filed it back in 22, right? So I
Oh,
mean,
okay.
everyone knew this thing was coming down the pipe. They actually filed it in 2022, but obviously they couldn't resolve it because there's no harm yet on something that had
Yeah.
not yet become,
Yeah.
was something that had the force of law. So it couldn't move forward, but everything was already in place years ago for this fight.
Yeah, so if you're wondering what we're talking about as the listener, we're talking about the Corporate Transparency Act, which basically has tentacles reaching into every state, every person forming a limited liability company, from just your general business owner down to a real estate investor who wants to just have a property or a LLC that's a holding company. This impacts you. This impacts us as attorneys who create and form LLCs. It's a massive law. In fact, we had an entire show devoted to it a couple weeks back with Natalia Olek Rice out of Florida. But this is something that we're really watching now and going to dive into more as it plays out. I'm sure that this is going to be just the first among many lawsuits and possible challenges to the constitutionality of the law. And of course, this law will work its way up the appellate process. But we'll have to continue probing you over there, Drew. Get ready. Since you're our local Alabama guy, we're going to be looking to you for answers.
I will certainly read up on it. I don't know if y'all have seen, but they're also, now that this is in place, they're also looking at expanding the geographic targeting orders nationwide. I don't know if you're familiar with those. Are y'all in a jurisdiction that has a geographic targeting order?
No.
So some jurisdictions, and none of them are mine, but I get the emails, about it from our underwriters. But some jurisdictions, such as Baltimore, are subject to federal geographic targeting orders, which says any property that is sold for cash over a certain dollar value, you are required to report to FinCEN already, right? So we know that FinCEN is in charge of the CTA, right?
Mm-hmm.
But in addition to that, they're also in charge of these geographic targeting orders that are also supposedly linked to, figuring out money laundering. And again, if you are a title company or you're closing in those jurisdictions, anytime you have a transaction that meets that criteria, again, I think in Baltimore it's like a cash transaction involving real estate of $500,000 or more. In addition to filing everything else, you also have to go take time out to go file an order with FinCEN. Again, very similar to what's in the CTA. Who's the buyer? Who's the seller? What's the property involved? So yes, they are becoming the Leviathan.
Good night.
In this case. And again, now hot off the heels of the CTA, they want to make that geographic targeting order nationwide. So every cash transaction in every jurisdiction that's over a certain dollar amount, you would have to file basically a suspicious activity report with FinCEN.
Wow.
So investors, get ready if they pull that off. Even more paperwork.
Yeah, the good times are over, folks. The reporting's coming unless the courts agree that there's a constitutionality problem with the Corporate Transparency Act, but something to watch. Hey guys, well we're at about an hour. We had a lot of questions. Good episode, Drew. Thanks for your time. I always look forward to doing it with you, and look forward to doing it next time. You guys have a good evening.
All right, y'all too. Bye, everyone.
All right. We'll see you guys. See you.